Hello, everyone. Welcome to IPWatchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IPWatchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Gene Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee. Welcome, everyone, to this week's episode of IPWatchdog Unleashed. This week, we're going to pick up where we left off several weeks ago with respect to patent monetization. To refresh our recollection, several weeks ago, I had a conversation with Dean Giebel, who is Chief Patent Counsel for Samtec, and Carl Marsh, who leads the patent advisory and monetization practice at Hilco Global. In that conversation, which we titled Patent Monetization Reality Check, Can Your Patent Portfolio Survive Due Diligence? We talked about the diligence required to understand what a company actually owns. This is the first critical step on the monetization path, as non-glamorous as the work is. It is essential for companies to ask some basic but frequently uncomfortable questions before they can credibly pursue any monetization strategy. What patents are core? Which patents are defensive? Which patents may be more valuable to someone else than the company that owns the patent or patent portfolio? Where has the company accumulated too much protection in any one area, and has that left concentration gaps in other areas that now need to be filled before you move forward? These and other questions were the focus of our episode on June 30th. Today, we return to the monetization conversation, picking up after the patent owner has done the heavy lifting to prepare for either a licensing or enforcement campaign. So we pivot now to discuss taking action. What is it that patent owners need to know? What actions will they take? How can they and how should they move forward? Moderating this conversation, which took place at our annual Patent Masters program, is my good friend Brad Close. Brad and I have known each other for over 30 years. We went to law school together at Franklin Pierce, and today he's the Executive Vice President of Trans-Pacific IP. Brad is a former patent broker turned patent owner and monetizer. He is a patent attorney, and he's done just about everything in the patent business. On the panel are also Phil Goder, partner with Barnes & Thornburg, Kyle Vallecillo, who is Senior IP Counsel for LG Energy Solution, and Matheus Ramalho, who is a partner with Licks Attorneys. We pick up the conversation after panel introductions and with Brad discussing the unfortunate reality that delay tactics favor the alleged infringer.
So when you're dealing with patent infringement, the infringer, time favors the infringer. The longer they can hold out, the more they get away with, and the longer they get away with it, and sometimes just entirely. So maybe, and things I didn't know is that Brazil has a lot of strategies and things available for dealing with holdouts that just don't exist anywhere else. So stay tuned for that one. So Phil, for someone that is using litigation financing, a case in the United States, if you're paying full rates for attorneys, it's going to run you $12 to $20 million pretty easily for a litigation, and that's assuming that you even get a relatively quick venue. So litigation financing it's a loan. People could go to a bank, but it's better in some cases to deal with people, the professionals who know what they're doing, who are in this space, that are used to seeing it. So can you tell us, for people that don't know, what a general structure of a litigation financing might look like?
Sure. So litigation financing has evolved even in the couple of years since I left Omni Bridgeway, right? It's gotten more sophisticated, more complex. But the straight and narrow on it is it's non-recourse financing. So when I said place a bet, like that is literally what I did. I had to pick winners, investment opportunities, cases that I perceived as winners, and I would finance them. And it's non-recourse, so if I picked incorrectly, our investors at Omni Bridgeway lost their capital, right? In an investment opportunity, a litigation, if you win, that is the collateral for that investment, right? So any proceeds that are received as part of the resolution, whether it's a jury verdict, more often a settlement, that is what is split up to pay for the attorney's fees and the costs involved in bringing a patent litigation. Now, how do you do that, right? You're not paying $12 to $20 million. So you alluded to some sort of alternative fee arrangement with a law firm.
Yeah, good time to jump into that.
Law firms that engage litigation financing on behalf of clients, they defer a portion of their fees, right? So everyone's aligned. They'll defer 50%, 40% of their fees. They will have some upside in that resolution value alongside the funder. And so that 12 turns into maybe 6, right?
And just so everybody knows, it's a lot more common to see that on fees, but not necessarily costs, hard costs, third-party costs, kind of thing. So if that 12 turns into 6, the litigation financer still has $2-3 million to back on the cost too.
And 100% contingency shops, firms will, a lot of firms out there, it's all contingency, but firms aren't banks, right, as you all know. So the hard capital, the costs for the experts and the depositions and the travel, filing fees, everything like that, that even those firms will seek some sort of funding arrangement to cover the hard capital costs.
And so if I'm a patent holder and I'm wondering what a contingency attorney would be taking, maybe I can get them down to as low as 50% of their rates, and in exchange, there's some upside for the attorneys as well, some piece of ultimate settlements.
Correct. Yeah, I mean, when we would, back when I was going on the speaking tour on behalf of my former employer, the general rule of thumb the starting proposition was that the claimant, the plaintiff, the patent owner, should get 50% so that they make the right decisions, right? The funder gets 30%. They're taking more risks than the law firm maybe gets 20%. So those are like the starting points from where you figure out, does it make sense to even seek funding and this sort of thing?
Generally speaking, each case can be a little bit different.
Each case is very different.
Generally speaking,
can be very different.
Those are the numbers. And a pet peeve of mine is how some people attack litigation financing. As I said, you can go to a bank, you can go to friends, you can go to your company. Why are we picking on these people that know what they're doing? And you say bet. But everyone's taking a bet. If I'm suing someone, I'm taking a bet. The lawyers are taking a bet. Bet has almost become a bad word, but it's sort of the truth of the matter is just how you define bet. And really, I think it often gets a bad rap among some judges and among some press. So,
well, the reality, Brad, just to defend my practice and my former employer, we are not investing. We have no interest in investing in cases that are not very highly likely to win.
Yes.
Because otherwise, if we invested in a lot of, junk bonds and, B minus C plus credit, we would lose money. Well, and the cost would be much, much higher.
Now you're on my second pet peeve. It is in regards to, say, what happened at the original PTAB, where you're seeing a kill rate of, depending on the metrics, 75 or 80% of the claims. And we seem to be missing the point that most of the patents that you're filing suit on, they're the creme de la creme. Like there's always the Pokemon one or something that gets a lot of bad publicity. But for the most part, if I'm going to your law firm and saying, cut 50% of your rates for me, you're not going to do it on a garbage patent. And when you put on your Omni hat, can I have millions of dollars to go do that? You're not going to do it on garbage patents. So there's multiple levels of checks on the quality before it gets that far.
I was talking to Phil before this, and just the idea of litigation financing where somebody's investing in the litigation, and I was analogized it to just like somebody investing in an inventor who has an idea and they need patent protection and they need financial backing to achieve that. So it's analogous in that way that the idea is that you have somebody believing in your vision, even if it's not even tangible at that point.
Now, so some companies don't create special SPVs to help go out and enforce. Although I think that's a great thing, and it really puts focus on that company, on Tulip, for example, that's doing it. There's often this in-house pressure to put your patents into a pool. Now, some people may not know what that is and what that means. Would you care to educate?
Yeah, so we generally have we're a high volume filer. So our patents cover the technology that's actually being invented in Korea. Whether or not it gets implemented as an end product, I don't know. But generally we have, I think, close to 100,000 patents as of right now, well over 10,000 in the United States. And from that, you'd like to monetize that so that the IP center and the R&D can keep moving forward. So right now, there is no, batteries are still at its infancy, and there's no standard, there's no set patents for batteries. So in other words, there's no like standard that they put out there that a competitor could not navigate around without actually practicing the standard. So right now we're in the patent pool business, and so basically it's what we've determined as the best way to monetize the portfolio without actually even, there's another side to it. We don't like putting our names on litigation and being known to be a litigious company. So it also saves face there to have a separate vehicle that could actually explain to another entity that you're infringing, and it's a broker too, so it's there to then now make business by doing a cross-license between our patents and Panasonic's patents. So it creates a business opportunity to reinvest into the IP center. And just to explain just why there's no steps is that we don't even have a proper format yet for batteries. So if you have an EV outside and it's a Tesla, we manufacture Tesla battery cells. They will be cylindrical cells, so they look like the shape of a big AA battery. If you have a GM vehicle, you'll likely have a pouch type design. And I forgot, I brought one from the office.
Right. Don't shock yourself in front of me.
Yeah, no, this is inert. I actually owe the guy a lot of bottles of Virginia wine who made this, because he actually had to stop the manufacturing process, because what makes it dangerous is the electrolyte. And so he had to get some of his engine. So when I thought I was just asking for a favor, he saw it as it's like an engineering like an object that he needed to accomplish. So he's like, I wonder if I could pull out a cell.
A big challenge.
Yeah, exactly, like a challenge. And they were able to accomplish it. So they were able to pull the cell out mid-manufacturing and then put it to a later stage without it injecting the electrolyte, which would make it, the flammable and basically it could be a fire hazard. But yeah, this one's safe. And then the last one you have for the formats is it's prismatic, and that's what the Chinese usually rely on. It's just, imagine like a fruit by the fruit, like a jelly roll, and it goes into a box, and that's pretty much it. So those are the three formats, and right now nobody knows which one's going to be the winner. So it's hard to say that there's SEPs in the battery space when you haven't even had people decide what the format is going to be.
When you do get to SEPs, though, and let's say down the road and you're still an in-house counsel, or working with the licensing group, there is an attractiveness to participating in them, because you just say to the standards organization, here's a list of patents. We think these are all SEPs, but ultimately the SEP organization says yes, no, yes, no. Yeah. And whoever pays money to license into that, you just get a piece of it. So it's very low work, high reward, for your business unit.
Yeah, it's my retirement plan.
So have you had any experience with SEPs, or sort of what's the goal that you would encourage in-house people to keep in mind about SEPs and pools?
Personally, this is an LG's opinion. Personally, if you have proprietary technology and SEPs are not there yet, you'll make more money with a patent pool than if you put it into than if they were designated SEPs, because then you're under FRAND, so you make less money. So in terms of monetization, you would not want any of your patents to be labeled as a SEP. Okay. Friends of mine have told me to stop using standard when I find something that I like. That's a really nice patent. It could be a standard. Stop.
Yeah, but of course you're never going to be unfair.
No, absolutely not.
Okay, so,
always ethical.
So Matt, we touched briefly on holdouts. So in the U.S., getting things like attorney's fees and and interest, it is next to impossible. Like the malfeasance has to be egregious, and that's also the structure of open courts for all kind of thing. And then you have the European system, often where loser compays or you have to post bonds. So tell me just more about how things happen in Brazil.
Sure. In Brazil, we have a standard rule. Likewise, you pointed out, which each party bears the cost of its own attorney. But in Brazil, we have something that we call fees awarded to the winning counsel, that we name sucumbência. It's not a contingent fee because it does not belong to the client. It belongs to the attorney. So whenever you litigate there, you win or you lose, the attorney is awarded a premium, like 10%, 20% of the economic value of the dispute. But this is not, this is the standard package of the situation. But a new horizon, which is now opening, not new because not new in Brazil, but in SAP litigation and patent litigation, is that there are some consequences for enduring into holdout tactics.
Preliminary injunction is kind of what made Brazil famous.
Yeah.
It's a big market. You can get a preliminary injunction. That really encourages people to take a license. As I say, any motivation to stop the holdout, to stop the delay, because delay just favors the infringer. I wish we had a little bit more time to get into all the details. Kyle, back to you. You talked about how owners, companies may not want to attach their name to litigation. Why don't we unpack that a little bit more too?
That becomes more of a PR issue with the company, and also like a C-suite determination about how they want to be known as being litigious, or maybe there might be a time period where they say enough's enough and that we will attach our name to this litigation to make, maybe it's like the first of its kind, so they'll make a show, I should say a show, but it'll basically be
like send a message.
Yes, exactly. Send a message to the infringers.
But it's very common. A lot of companies that I deal with have patents. They just don't want to get involved in the litigation, and it's a business consideration.
Yeah,
so
they want to get involved in litigation in terms of a monetary perspective, that they want their investment back. And also what's unique about this technology with the batteries is that Korea has import-export laws in terms of technology control. So they've identified core technology. So it becomes a reputational issue as well with the country, saying that if you're infringing on our patents, you're not only just infringing on this, but also the core technology developed in this particular country. And then that could get into a geopolitical issue because determining on who you're suing.
Yeah, so I think one of the short answers is there's a lot of business decisions that go into whether or not you attach your name to a litigation, and sometimes just selling it, even if you think it's valuable, selling it is the way to go to make money.
Yeah, and I want to add too that it's not just as simple as just somebody signing paperwork that says, yes, I have a license. You also have to, it's weird you have to do this, but you also have to help them develop a narrative of why they're doing it, especially for them to save face. If they don't want to be known as they're a copycat, infringer, or latecomer, whatever have you, that they are attaching themselves to this pool because they also want to invest or something like that. So you also have to develop that narrative to as a mutual business relationship for the monetization.
So are you saying something like company A has the patents, and then company B may pay into the pool but also contribute?
They could. That would be a business decision completely for the pool.
Yeah.
Not, but it's at the end of the day, it's a business decision, and it's so much as a business decision as whether or not it's monetization or whether it shows up in a different way, such as supply. I'll give you an example. It's not a real example, but we sued an end user product, and they need batteries for their product, and we sued them because the batteries they currently have are infringing. What if instead of them just not only taking a license, maybe they would have us as a supplier or something? But that's above me.
Yeah.
It's so far above me.
No, but that would be a great situation. Yeah. And that's actually something that if you're using litigation financing, you have to watch out for, because if you're giving the money for a litigation, it can't be that a resolution is just a cross license, for example, because you need to see a return on investment. Right?
Global competitor suits are bad litigation finance investments.
Yeah. You want to talk about that for just a
Sure.
second?
we saw 5G, right? That was quickly resolved. What was that, 3-4 years ago? We saw what seemed to be, it's going to be long and protracted, like 4G was. But most of that resolved pretty quickly, within less than a year. And it's just moving chess pieces around the board to advantageous bargaining positions so that you can cross-license your portfolio, setting aside SEPs and all that, your patent portfolio covering 5G, with your competitors who also have patents that you probably infringe in 5G, right? And litigation is just moving more pieces on the chessboard and establishing positions of strength for negotiations. Mm-hmm. And that's no different than the end goal for monetization for really any company, right? Litigation sometimes is a necessary tool to further your monetization and your licensing interests.
Right. So if you are going to ask for litigation financing or consider it, you have to be clear that your end goal is a big pot of money and not necessarily just a business relationship. Otherwise, it'll be over before it starts.
Right.
On that.
And if I can, strong portfolios for monetization, I like to get involved early and even help the clients, the startups, build the portfolios. Because evidence of use charts, identifying targets, all of those things. Well, when you're building out your portfolio, you basically are building out your evidence of use charts. If you're doing it in the right way, you're identifying who are your competitors in the future. You're sitting down with the engineers. You're saying, okay, what is your invention? And then you ask them, how are all the different ways this could be implemented? And they will say, well, we picked the best one because they're engineers, and all the other ones are no good and they won't work. It's like, well, okay, but there's a thing called non-infringing alternatives out there. Maybe we should cover those too, because that increases the value of our patent, right? It increases the size of our fence, the size of our property, our competitive moat, whatever analogy you wanna play out for them. You want to get them to disclose as much as you possibly can about who they see competing against them, and you want to try to cover as much of that as you can. And when you come to us, or when you're thinking about litigation as part of the monetization plan, you build, I think, patents that are a little more litigation proof. If we're not involved, we have to identify targets, right? And we're looking at if these really are foundational patents that are worth $1 billion, Mr. or Mrs. Inventor, who in your competitors or which of your targets have cited them as prior art to their own innovations? Figuring all those sorts of things out. And, are you in the unfortunate circumstance that you filed your patents back in 2002 and now 101 has put you in very uncharted territory, right? No fault of your own, the law has changed, right? Is that a risk to collecting what you want to collect? So we walk through all of those things, and in the end, right, the litigation financier will do the same thing. Me determining whether I'm going to invest my time, my people's time, any further in due diligence pre-suit or pre-monetization. We want to be pretty sure on those things, and then also, do you even own what you say you own? Right?
Yeah, so you touch on this, which is a very central to my work. It's not hyperbole to say that out of 20 portfolios, we're looking at just 19 just get passed. We don't pick them up for just basically the damages, infringement, validity, venue, all those very high-level considerations. Keep in mind litigation is very expensive. Damages have to be correspondingly big. So it's an immense amount of work when you're looking through portfolios to find the good stuff, to find the gems and see which ones are worth it. But what a lot of people may not appreciate about contingency fee lawyers is that they help us through some of the, a few portfolios might make it past a couple gates, but then I'll go, Phil, I need some help with this portfolio. And just a word of caution for anyone that just thinks they can jump into contingency fee practice is you have an enormous amount of front-loaded work before you take on cases.
Culling the many, many opportunities that come to us quickly and efficiently is in everyone's interest. And so we've gotten pretty good at that. Are there marking issues? Have you licensed before? some of these threshold, like setting aside the merits of infringement. We almost never really dig into that until the very end. But is it induced infringement? Is it contrib? Is it divided infringement? Have you licensed these before? Are you a university professor that received a bunch of grant money and maybe there are interests in your patents that you're not even aware of, right? We have to run all those things to ground. Mm-hmm. What is the size of the market, right? Are these consumer products? Is there a long campaign here, or are we looking at just one particular target? And then what could damages be? And only if we really like those kind of threshold things do we dig in on the technical merits.
So that you've just described an enormous amount of work before even taking on the case.
Right.
So that's something to keep in mind. People that may have an idea that clients say, we have patent 555, would like to pay you to enforce it. You just can't do that as a contingency thing. You have to check out everything, even if they did say we have a specific patent, which normally they say we have a portfolio. Help us move along with that.
Right.
So I think that there's
patience can be a virtue
appreciation
of the patent owners in this process.
Yeah. So we're at less than 10 minutes. So Matt, why don't we start with you? Any sort of summary or take home?
If I were to summarize the whole monetization thing, is that sometimes I think that it's important to have caution. What you're doing elsewhere impacts your local assertion. So nowadays, the entering licensing issued by the UK court is used in Brazilian suits to disturb and ask for the dismissal of the case. Or sometimes the way you portray your offer, your rent offer with arbitration, depending on how you structure it and the treatment for your setting the friend rate of your portfolio, this could kill your assertion. And this risk is real, but since our clients usually have the habit of dividing everything, we have the ability to advise, because we're talking about monetization. So the first thing is, be sure that all your moves are not taking out your pressure points instead of putting them on. And a second point that I would like to bring up, I'll use Brazilian case as an example, but this is not me just talking about Brazil, it's just an example. In Brazil, besides the PI that I already explained, people don't realize, but our criteria for damages calculation is disgorgement of profits. So in Brazil, some of the implementers that are asserted and that delve into holdout tactics, they are massive. Probably there are some of them which they are global leaders and they do not sell as much as they sell in Brazil. People sometimes overlook the market share and the impact of these markets into their campaigns. So sometimes I think that people are so focused on finding the licensing range of their portfolio that they're not thinking that the holdout should make the implementer pay more and comprise these damages. And I don't know if these calculations are considered, such as the contingency fee for the negotiation. I'm not saying that I'm not altering that the negotiation, the deal is the main goal. But since we are discussing monetization strategies, so are you considering everything you have or you can extract from that in your negotiation table when you're setting this? Because the gains you get from an infringement, they are asymmetrical. You can destroy equipment, you can gather information, you can have both damages and PI in Brazil. So I never happen to discuss this over clients because they're sometimes just focused on a confirmation, but not all the times the same patent is asserted globally. Actually, our clients do the opposite. Usually the Brazil is a different patent that was never asserted, and the cases are independent.
And about what you heard, $12 to $20 million, roughly speaking, for the U.S. What would that cost in Brazil for a patent case just in Brazil?
This varies a lot because there are different arrangements, but I think in billable hours, depending on the case, $5 to $1 million, depending on the number of patents that you are asserting with. But nowadays, our firm works with waves of lawsuits with a hard cap. So this is all agreeable depending on the time. We have a time projection where we have the cap, but we make things align it. So we are flexible in these arrangements.
Okay, well, there's a lot going on in Brazil, so my takeaway is to talk more to Matt if you want to go there, because there's a lot of things that I hadn't even considered even just last week before we talked. So Kyle, your take-home message.
My take-home message for if you're prosecuting applications that you know are designed to be monetized, I would think in the way of how would somebody infringe those claims, and whether or not those limitations, you need all of them. Because at the end of the day, when we do teardowns, each one of those limitations has to be met. And some of those tests can be more than $13,000 just to meet a redundant limitation that everyone knows it's there in the component, but you still have to prove it for evidence of use. So,
yeah, reverse engineering can be a huge cost on a portfolio, that for sure. Okay. And also, I think part of my takeaway from yours is just the structure of how companies can monetize. That the easy way out is the patent pools, but creating different structures, whole different companies, it's a good way to go.
yes.
Bill?
Takeaways. So I mentioned patience, right? We often see inventors, companies, startups, their patents are in process, right? There's nothing to enforce, there's no damages. One patent issues. Well, one patent is a good start. The DivX general counsel said she likes to see multiple patent families filed on their foundational technology right away. And I like to see the same thing. It's easier to kill off one family where the claims are basically all the same than it is to attack multiple families. So diversification of risk, putting on my investment hat, whether it's money or my time, I want to see multiple families. I want to see I don't want to see a nascent market, I want to see an actual market where there have been infringing sales. And I want to see that for a few years, right?
Yeah.
Because ongoing royalties and things like that, designer rounds come in. So just because you have one patent and it issued today, I would say you're generally not ready for monetization yet. You have a little more work to do.
Yeah, certainly. I get a lot of reach outs from people, LinkedIn messages saying my patent just issued. Well, that's not a good sign. I have one patent. Well, that's not a good sign. So the number of patents, we didn't even talk about that for monetization. Before the PTAB sort of calmed down a little bit through these great new reforms we're seeing, we would sometimes look at cases where you need like 5, 6, 10 assertable patents because of the death squad that you knew was coming. How is sort of the number of patents, number of families, by that I sort of mean the families, what do you want to see? You certainly want to see more than one. Is 4 a really good number? 5? What's your thinking?
3, 4, 5, 6 independent assets, we'll call them, is a very good start. Obviously, depending on your venue, you're going to go to trial on 2, maybe 1.
Because you aren't actually going to go to trial on all of them.
But you like optionality early on.
Yeah, because some are going to may get killed from 101 or the PTAB. It's still there,
right?
Or re-exam, or just
101 is only narrowing the landscape of patent eligibility. It'll never go the other way.
It's been said many times before. The infringer has to win once. The patent holder has to win 10 or 12 times.
Well, and 101 is binary risk, right?
Yeah.
So when you look at it from that perspective, it's binary risk that recurs throughout the life cycle of the monetization campaign.
Yeah. So number of patents, it's key. And then on those, of course, you need the damages, which is going to be coming up next. I'm looking forward to that one. Gene, I think we'll turn the microphone back to you.
Great. Thanks, Brad. What I'll ask you, do you have a takeaway message yourself?
I think it's what you heard in the end there is, I really wish that I could help inventors more. I get approached by inventors and say, I have this patent. And I say, well, with the current economics, that if the damages aren't $100 million, we can't put together the financing necessary to take this to court. So if you're hoping for, this is being infringed, the market is 50 million, it's just not there, and that's a shame. So I really wish that it was better news for the small inventor, but my takeaway is it's not necessarily a fair system that we have for the small guy.
Yeah, fair is where you go to put a ribbon on a pig. It's not where you go for the patent system.
Yeah,
But
very true.
that's where we live. But thank you guys. That was a great panel. I really appreciate it.
Thank you.